Welcome back, everyone. Welcome back to the show. I'm your host, Alex Wellings. This week, we have a very, very special show. This has been, every week we've gotten more and more people responding back to the show that they really loved the content. They learned a lot. They're taking home a lot of good information back to the practice. This week should be no different. This was the highest question, or the most frequently asked question, I should say. What is the Secure Act, and what do we do with it, and how might it benefit us as advisors out doing retirement planning these next couple of years? And we were able to bring on a special guest. Her name is Heather Schreiber. She is 25 years in the business, 25 years of experience doing retirement planning, case design, Social Security. She is an RICP. She knows a lot. She is one of the most impressive people I've had the chance of chatting with in the financial business. She knows everything under the sun. And so she was nice enough to come on to the show and impart some wisdom about the Secure Act and what it means for all us advisors out there. So let's jump in with our interview with Heather Schreiber here on Coffee for Closers. Hope you enjoy. Welcome to the show, Heather. Thanks so much for joining us. Lots of years experience in the financial planning space and helping advisors better understand financial concepts, Social Security, IRAs, and obviously new laws, which is why we brought you onto the show to chat a little bit more about the Secure Act. So thanks for being on the show, first and foremost.
Thank you, Alex.
Yeah. So I guess we've been getting obviously a ton of questions about the Secure Act and what it means for advisors. And I figured maybe we could just start off with talking a little bit about the overview of the law. So maybe you could just kind of overview what the law meant when it went into play, and then we'll talk a little bit more about what that means for advisors in the planning space.
Sure, I can absolutely do that. So first and foremost, the Secure Act, which, most advisors I'm sure have read, it's been something that's sort of been on the playbook for well over a year. And it couldn't get bipartisan approval. So there was a House version, there was a Senate version, and it sort of just kept stalling. And so we thought, and myself included, that this thing was just going to get sort of lost, not get approved before the elections, and then it would just take a back seat. Well, what happened is on December 20th, the Further Consolidated Appropriations Act, that's a mouthful, I know, but it was approved and passed on December 20th in the wee hours of the night. And yes, I was looking it was like 11:30 at night when it finally was signed into law by the president. But in that contained several other smaller bills, the Secure Act being part of it. So at the very last minute, when those of us that follow this stuff like I do thought there's no way this is going to happen unless it gets tied to a larger budgetary bill, because obviously they were trying to avoid government shutdown, so we knew there was a likelihood that something like that would pass, but they just tied the Secure Act into it. And so that is actually Division O of the larger bill. So if you're looking for Secure Act, you'd find that in the larger bill. So it passed December 20th. Of course, with anything that is related to tax law, there's all kinds of effective dates. Some of the effective dates within the bill started immediately. A lot of them went into effect on January 1. There are some that are even not into effect for a couple of years. But it was quite literally the most expansive set of retirement changes to occur since probably the Pension Portability Act. So well over 10 years. And
Wow.
so, of course, it's the talk. I get emails every single day about what does this mean? I see some things that are accurate, some that are not. And so I guess, if I had to break down a very large Secure Act bill into pieces, I would say it had three overwhelming themes. One of the themes was incentivizing small businesses in particular to establish workplace retirement plans. We know, and I know you know, Alex, that defined benefit plans are going by the wayside. And so, the idea is that we as employees need to start taking a more active role in making sure that we have retirement income. And so we've seen over the years defined benefit plans going down, defined contribution plans going up, such that 401ks, simple IRAs, those types of plans have really have grown in the large business space, but in the small business space, they're still kind of lagging. And so there are a couple of incentives, new startup costs or startup credits, I should say, that really incents small business plans or small business owners to create these plans, even existing plans. There's a brand new credit for plans that are already in existence, but that add an automatic enrollment feature. What is that? That means that, unless you otherwise opt out, an employee is automatically enrolled at, let's say, a 3% deferral rate in a 401k and
Right.
single IRA. So those kinds of things. There's a lot of changes on this on the retirement plan front on qualified plans. There is going to be in the future, not effective anytime soon, but in 2021, employers in the 401k space and the defined contribution space will now have to offer the ability to defer into a 401k plan to long-time part-time employees. So before, historically, they could eliminate, or not include employees that didn't have at least 1,000 hours of service. So they're going to require that these folks, if they have 3 years of prior service and have at least 500 hours of service, they now have to be permitted to be participate in the plan, and that's not coming up until 2021. So
Wow.
those are the kind of things that affected the small business or just retirement plans in general on the qualified side. The other big one, that I saw as a theme, and is a good theme for those of us that work in the guaranteed income space and think that that's an important part of retirement, is the fact that there were definite nods toward the fact that guaranteed income sources like annuities are definitely something that should be considered with respect to creating a retirement income plan. One way they did,
That's
go ahead.
that's that's something that I had heard from a couple of advisors. They were reaching out to me saying that there was maybe some legislation either already in place or that was going to come down the pike that was about employees' 401k plans offering annuity options for distribution of that asset. Is that
Yeah, so
true or?
there's three ways. One of the things that changed was that 401ks, for example, that already offered an annuity as an investment option, if for whatever reason they no longer offered it. Although I see that it's probably going to be the opposite. I think more 401k sponsors are going to be offering them, and I'll tell you why in a minute. But if they stopped offering it, prior to this, they could just terminate that investment option, and then the employee would just have to sort of, redirect that to some other available investment choice. So the act
Right.
contained a provision that essentially says if your plan no longer offers this type of guaranteed income solution and you want it, we will allow, despite the fact that you may not be eligible for an in-service withdrawal, will allow you to move it to an equivalent guaranteed income contract under the guise
Wow.
of the plan, but still able to get to it so that that isn't a lost investment. So that's one way. The other way, that income, guaranteed income feature was sort of put on a pedestal before, it hasn't been in the past, was that, a lot of 401k sponsors, people ask me all the time, producers say, hey, I've got a client, a big 401k client, can they have an annuity in the plan? And I say, yes, they can, provided um, the investments permit it. But a lot of employers didn't want to do it because they were afraid of the concern that employees would come back and say, hey, it didn't perform as planned, and so I'm going to come back at you. So
Hmm.
the Secure Act created what's called a fiduciary safe harbor. There is going to be more guidance on what that's going to entail, but essentially it would protect the plan sponsor, the employer, from any liability if if an insurance provider under the plan that was offering the guaranteed income didn't pay on their promised benefits. Now, obviously, hopefully that wouldn't happen because we're going to select, creditable insurance carriers for the plan. But
Sure.
if the employer followed certain guidelines to select a suitable guaranteed income annuity inside the plan, then if they did that, they were not held personally liable for any issues down the road. So that's big because I think that was sort of the block that a lot of employers had to having an annuity. They don't understand it, nor do they really want to get into all of that. So that was a big nod that yes, in fact, looking at sources of guaranteed income inside of a plan is something that should be considered. Additional guidance is coming out on that from the DOL, but for now, it is there and effectively could happen now. They could follow the guidelines outlined within the Secure Act on that section, and as long as they do, they would have the safe harbor applied
Wow.
to them. And then the other one that I thought was good, and some 401k statements already do this, but starting in 2021, 401k statements at least once per year are going to have to provide an equivalent income, um, like an equivalent income to the instead of just showing the account balance, they're going to have to say this would is what it would be in a monthly income. Again,
That's really
it
interesting.
is
That's
good,
really interesting.
and again, this is yet another one that the DOL has to now come out and say, okay, what are the assumptions that are going to be made? Because clearly, this is going to fall probably on the investment provider to do it. But it would be something like showing what it would be on a single life, showing what it would be joint life with a spouse similar in age. I mean, it's going to be generic, but at least it's showing, hey, we can't just look at account balances. We have to look at really what does this equate to in income? Because a lot of people are ill prepared for retirement and think that the balance that they have will sustain them. So I think this is a reality check for employees, and so I
Hmm.
thought that was a good one. So those are the three ways that guaranteed income annuities are sort of given a favorable bump within this legislation. And then the
So,
final one that I get most of the questions on was, and again, there's lots of other things, but in the interest of time, we won't go into it. But the other one was what I call the death of the stretch. And this is where
yep.
many of my questions have come from. And so, what does that mean? Well, the Secure Act, like I said, has been going back and forth for a couple of years now. And there was at one time the idea that they were just going to wipe out any semblance of stretching over life expectancy and replace it all with a 5-year rule. Well, they didn't do that, but they did instead replace the 5-year rule with a 10-year rule. And so that means that instead of being able for a designated beneficiary, and that's someone who is a human being that we can measure their life, or in some cases, a trust that we can look through the trust to measure the life expectancy of the trust beneficiary. Historically, before the Secure Act, they could stretch distributions over their own life expectancy, take those annually, and really create a lasting legacy that was tax deferred until withdrawn. And in the case of a Roth IRA, was tax free for many years, so it continued to earn tax deferral that was never taxed. So, but now, unless you fall into certain categories of individuals, you are bound by at death. The beneficiary has to take the distributions out by the 10th year after death.
Right.
This isn't an annual RMD requirement. That's one of the questions I've gotten. It is simply one RMD by the end of the 10th year containing the 10th anniversary of death. So, what does this mean? Well, it's a problem for a lot of beneficiaries. Think about grown children that are named as the beneficiaries of their parents' IRAs. They were expecting to be able to perhaps take distributions over a period of time to even sustain their own retirement. And now they're looking at having to take one distribution at the end of year 10, you know, maybe when they're in their highest earning years, and be creating a real tax problem.
For the
Um,
entirety of the account, right?
yes, yes. So now I said that there are some exceptions, so I'll give you what the exceptions are. If death of the IRA owner or qualified plan owner occurred before January 1 of this year, then those beneficiaries would follow the pre-Secure Act rules. In other words, they would have to start taking their first distribution by 12/31 of this year over life expectancy. They would still be able to do that. The challenge, though, becomes when we're dealing with annuities. I've seen a lot of the carriers come out with their various stances on this. Some of them have come out and said, we will, um, we'll continue to honor, um, inherited IRAs or stretch IRAs for decedents prior to the January of 2020. Some have just said, we're no longer going to take it at all. So you have to be careful about that. So those folks are technically grandfathered. Your challenge then is going to be finding the carrier that will take it. Um, Anybody else who was, that dies January 1 or after is subject to the 10-year rule unless they fall into what's called the eligible designated beneficiary category. This is a brand new category. And essentially, it's four types of beneficiaries, I guess five. One would be the surviving spouse. So the rules surrounding a spouse as beneficiary have not changed. So if a spouse is beneficiary, he or she can still assume ownership, treat the IRA as an inherited IRA to avoid the 10% penalty on any distributions they might need before 59 and a half. Transfer it however they want it. They can treat it as their own, use their own life expectancy. A minor child is also an eligible designated beneficiary. And here's the critical thing about that. If a minor child is named as the beneficiary of a contract, and by the way, that should never happen absent of, some sort of UGMA or UTMA registration, because minor children can't assume any sizable assets. But let's just say that we
Sure.
have a 5-year-old child that's named with grandma as the custodian or something. That is an eligible designated beneficiary. So until that child reaches the age of majority, those distributions can come out annually to the child based upon his or her life expectancy. But when the child reaches the age of majority, and that differs by state, it can be 18, it can be 21, they automatically, at that point that they reach that age, now are subject to the 10-year rule. So that's something that some people have missed. Um, the other category of eligible designated beneficiary is one that is disabled, permanently and totally disabled. So this would be one who's akin to being eligible for Social Security disability. They are, fall into those guidelines. They fall into the category of not having to adhere to the 10-year rule. And so they could stretch distributions over life expectancy. And then also a chronically ill individual. Again, certain guidelines to that, but those types of folks don't have to adhere to the 10-year rule. And the final category under eligible designated beneficiaries is a beneficiary that is no more than 10 years younger than the decedent. So that could
Right.
be any relation, but that's just basically the IRS saying, well, that distribution period is going to be far less than someone who named their 5-year-old grandchild. So we'll give you that. We'll allow you to take distributions over life expectancy. So those are the categories. Where I see some challenges is the fact that a lot of people use trusts in their planning. For example, they had
Yep.
two children that are responsible, and they had one that they don't trust. To get the money outright. So they created a trust for that beneficiary to, protect them from themselves. That's no longer going to work unless that beneficiary is also an eligible designated beneficiary. So there's a lot of ramifications and a ripple effect to the changes. The other thing that changed, sort of related but not, but I'll just mention it, is that the RMD age. So we've always known that April 1 of the year following the year that someone turns 70 and a half is the normal required beginning date. Well, for those folks that turn 70 and a half on January 1 of this year or later, they can now wait until the year that they turn 72. They obviously get until
Right.
April 1st of the following year, but age 72 is their cutoff or their time when they have to take distributions. Those folks that already turned 70 and a half last year just keep plugging along as if the Secure Act didn't pass. But so it gives some people some time to do some planning. Gives them more time to maybe do Roth conversions for a whole host of reasons. It could be because they're trying to mitigate, they don't want their RMDs, they're trying to mitigate it. They want to leave money to their grown children, but now know they're going to have an accelerated period of distribution within a 10-year period. And so leaving a Roth to them might be obviously more tax efficient for the beneficiary than a traditional IRA. So there's
Yeah.
some, ripple effects to that. And I'm talking fast because I know I could literally talk for 3 hours on this. But those are the big ones. I get tons of questions about both the RMD thing and the 10-year rule. Um, One of the questions I've gotten recently too quite often is what about qualified charitable distributions? Those are, if you know about them, are the ability for someone to transfer directly once they reach 70 and a half to a qualifying charity. So they transfer up to
Yep.
100,000, and then they essentially not only satisfy their RMD up to 100,000, but also get to do that tax free rather than a charitable deduction. Big difference. Well, so the question was then, okay, what is 70 and a half for QCDs? Now I'm subject to age 72 for my required beginning date. Which is it? Do I have to now wait? And the answer to that is that QCDs will remain available to anyone at 70 and a half or later. So, that is, I guess, a silver lining a little bit.
Yeah, that's shocking. I did not know that. That's
Yeah.
great.
Yeah. And then the other thing that also comes up is everyone says, what about these life expectancy tables? I don't know if you all have gotten questions about this, but
No, not at all.
there's
Go
been some
ahead.
rumblings about the fact that, the life expectancy tables have not been re-examined since the 60s. And clearly we see a trend of life expectancy increasing. So, the president said you need to go back and revisit these life expectancy tables, which the IRS did, and it is in pending form. So this was separate legislation from the Secure Act. But as it stands, we expect for these revised life expectancy tables that obviously will affect RMDs, making them slightly less than they would have been under the current life expectancy tables, to go into effect in 2021. But people are asking about it, thinking it's part of the Secure Act. It's not. It's a separate piece of pending legislation, and right now it's pending. So we should see, a slight decrease in RMDs for for anyone hitting that RMD age. So,
Do you think that could have a potential ripple effect into like Social Security claiming and such, or
well, I
no?
mean, sure. I mean, the fact that the life expectancy tables are more adequately reflect current longevity assumptions means that lower RMDs means less bleed on Social Security benefits, because we know that, to the extent that there is a taxable distribution or taxable income in retirement, that definitely can impact the net Social Security benefit, because Social Security becomes taxable, or a portion of it at least, at very small thresholds of income. So every
Hmm.
part of this has a ripple effect. I mean, I'm currently in the process of writing a paper, which y'all will get soon, about the death of the stretch and the ramifications of that, what it was, and how we pivot our planning strategies with it. It is not the end of the world, but you need to be on the front edge of talking to your legacy minded clients that have been sort of banking on the fact that they've got this amassed traditional IRA wealth or 401k wealth that they just expected to transfer on to generation and generation. And now we have to sort of pivot and say, okay, how do we solve for that? And so that's the topic of the next white paper that hopefully y'all will be receiving in the next month or so.
Well, we're very excited about that. And the only other thing that I would be interested to chat with is one that we're getting a lot of questions on. We do a lot with taxes. We run one of our marketing programs revolves around opening a tax prep service in an advisor's office.
Hmm.
And so a lot of advisors are trying to pivot and use this Secure Act as an even more almost a doubling down of the reasons to do a Roth conversion on assets. So maybe you could talk about the benefits of that Roth conversion, or maybe you have thoughts on that. I don't know.
Oh gosh, I have all kinds of thoughts on that. I have always been an advocate for Roth IRAs in general, or Roth 401ks if someone has the opportunity to do that. I tell my much younger siblings all the time, you will love me and thank me later. So just do a Roth 401k. Don't do pre-tax, because obviously we know that the benefits of Roth IRAs and eventually, Roth elections and 401ks means that eventually, under certain conditions, that gain is never taxed. So in the light of just in the death of the stretch for a lot of folks, Roth conversions even become more attractive. And the fact that the RMD age was delayed for a lot of people that are turning 70 and a half for later
Right.
this year gives them a little bit more time to do it. Because like you said, are there ripple effects in these changes? Absolutely. Roth IRAs, qualifying distributions from Roth IRAs don't go into the provisional income calculation when determining taxation of Social Security benefits. So that in and of itself, I've always said you need to consider. I always say tax diversification is equally as important as diversification investment wise. And so that becomes sort of, it's highlighted. Roth conversions now are becoming more attractive, because think about it. If you're trying to leave a legacy to children, you don't want to set them up for a tax torpedo by leaving them significant pre-tax IRA assets. If you can, then convert it so that you're leaving them a tax-free asset
Right.
that they have to have over 10 years. Also, for folks that don't need the RMDs, they hate it. I was working on a case yesterday. The guy's got $1.7 million in his qualified plan. And he's like, I hate it. I don't want to I'm retired. I'm going to be forced to do this. And we're talking about a series. He's uninsurable. So life insurance was sort of off the table, but we were talking about doing what I call serial Roth conversions, to take a little bit at a time, start that thing, and just take as much as you can muster to pay taxes on, to kind of better position yourself both from a retirement income standpoint, and if legacy planning is important to you, then it leaves, a more tax efficient legacy to heirs.
Sure. Sure. Well, Heather, I can't thank you enough for sharing your wisdom on the Secure Act and just educating us a little bit. I know you got another call to get on, but I was so happy to hear that you were able to do this, and I know I've learned a lot, and I'd love to do a little bit more. We're definitely looking forward to that paper that you'll be putting out. We'll be passing that out to all of our listeners and other advisors as well. And thank you very, very much.
You're welcome. Glad to do it.
Well, until next time, Heather, I appreciate it.
Thanks. Take care.
Take care. Well, there you go, everyone. Yet another episode of Coffee for Closers in the books. I hope you guys enjoyed learning a little bit more about the Secure Act and what it's going to mean for your practice. Next week, I have an interview with the superstar of the last 9 months at Megastar, an advisor that's been in the business for, I want to say, 5-6 years now, and has been a wrecking ball of production. I mean, this gentleman has produced more in a short amount of time than I have ever seen in the business. I know very few advisors that have tacked on this amount of production in all of 4 or 5 years. So next week I will be on an interview with Cameron out of Iowa. If you know Cameron, great. If you don't know him, buckle up, boys and gals, because we are going to be listening to one of the fastest growing businesses, practices at Megastar Advisors, and how he has done that. So don't forget to tune in next week on Coffee for Closers. Thanks again for listening, everybody. And don't forget, keep closing. Don't ever stop.